Hey everybody, this is Tracy here with another edition of Review from Tracy's Point. And we are here to talk about the latest update. In the case of the Eastern District of New York versus Robert Sylvester Kelly. So you guys know last week I shared with you the motion where they are appealing to the United States Second Circuit, trying to overrule Judge Donnelly's 3 denials for R. Kelly to be released pre-trial so that he can prepare for his case that's supposed to be coming up in September and another one in October. What I forgot to mention in that video is that they filed the appeal with the Second Circuit. The Second Circuit is under no obligation to, one, accept the appeal and agree to hear it, and nor are they in any obligation to respond right away. So we don't know when they are going to respond to the request. They could come back and say, you don't have enough evidence or a strong enough case for us to review it. Or they could come back and say, okay, yeah, we will review it. And then once they agree to review an appeal, I believe that's when they get invited to come into the court and go before the judge or whoever to basically present their argument. I know that's how it worked with the Bill Cosby case, because you guys know he was he filed an appeal for his conviction, and the lower court said they weren't going to hear the appeal, that he didn't have a strong enough case. But then recently, like in the past month or 2 to 3 weeks, the Supreme Court of Pennsylvania has come back and said, yes, we will hear your appeal. And so but still haven't given a date on when they're going to actually hear the appeal from his legal team. And so you figure Bill Cosby, September would be 2 years that he's been in prison. And I'm sure they filed that. So the first court came back last year and said that they weren't going to hear the appeal. So then they filed with the Pennsylvania Supreme Court, and they're just now coming back saying, yes, we will hear your case. And so although they filed the appeal in R. Kelly's case about the decision of Judge Donnelly, there really is no time frame on when they're going to respond. And then once they respond, if they do agree to hear the appeal, then I believe that's when they go into court to to state their case and say why they think that the judge's ruling should be overturned. And by then they could, the trial could be here, I guess is basically what I'm saying, if they have no expediency about it. So I guess in response to them filing that motion on R. Kelly's behalf, the Eastern District of New York is very petty. They're very tit for tat. And so this sounds like one of those tit for tat moments here. So they filed what is called it says the government's memorandum of law in support of its motion for an anonymous and partially sequestered jury. And so you guys know in the video that I did about a month ago, where I read the actual preliminary questionnaire that jurors will be given, it actually mentioned in there something about maybe wanting to request that the jury be sequestered or partially sequestered. And so now they have formally filed that motion. And what is bizarre about this, and I'm going to read through this, as I'm reading to you guys, I am actually reading this for the first time. But based on some of the articles that I've written where Steve Greenberg has spoken to TMZ, and I just think it's so interesting that the mainstream media is really not interested in this case, so he has to go to, like the TMZs and the Court TV to give his opinion. And then people, was saying that, he should be saying more on social media. And I just want to remind everybody that the defense team is under a gag order. So there's only so much that they can say when they're talking to the media. So it's like they can't really come out and speak about specifics of the case. They can't appear to be antagonizing or trying to, sway public opinion or any of that, because then the prosecution will come back and, try to charge them on stuff like that. So I think that's why they are treading lightly when it comes to talking to the media and only responding to specific instances like this, and basically making a vague statement like, I've never heard of, and the attorneys not being allowed to know, be a part of the jury process, selection process. And I believe that was all Steve Greenberg said. He said he agreed with sequestering the jury because it is a high profile case, but he doesn't agree with it being an anonymous case. And you guys remember when I was reading those questions and we were talking about like the employment, what do people do for a living, who they work for. And Greenberg made a good point. He was like, of course we need to know who these people work for, because they could pad the jury with people that work for the FBI, people that work for sexual assault victims, people, who are members of Me Too, so the defense needs to know who is on that jury, and they need to be actively, participating in the jury selection process. And so I'm reading this for the first time, and I may determine that that is not what they're saying at all, or that is what they're saying, and that Greenberg definitely needs to appeal this. And then also earlier today, I believe, or maybe it was late yesterday, because I believe this came out yesterday. I downloaded it last night, but I was babysitting my grandkids and didn't get to do this video. But Greenberg did file a motion, or whoever is over the New York case filed a motion asking for more time to respond. So they must be going to come back with some long, lengthy response to this motion. So let's go ahead and get into this. It says preliminary statement. The government respectfully submits this memorandum of law in support of its motion for an anonymous and partially sequestered jury in this case. For the reasons set forth below, the government respectfully requests that 1, the identities of all prospective jurors, including their names, address, and places of employment, not be revealed to either party of their attorneys. And 2, from the time each juror is impaneled until the conclusion of the trial, the jurors eat lunch together and be accompanied in and out of the courthouse by members of the United States Marshal Service each day, so they do not mingle in the courthouse with the public or any potential trial spectator. These measures are necessary to safeguard the jurors and the fair administration of justice. Moreover, these precautions will not deprive the defendant of meaningful jury selection, diminish the presumption of innocence, and cause any prejudice. Yeah, right. Now, it's not uncommon to request a jury to be sequestered. We know there have been plenty of juries that have been sequestered. And I believe the O.J. Simpson trial, don't quote me on this, but I believe the O.J. Simpson jury was sequestered. I know that the names of jurors are typically, or can be requested, not be revealed to the public, that they're not, named, that they're referred to as juror number 1, juror number 2. And you'll see in news articles about cases where they'll say the jury comprised of, 5 men, 7 women, that there's 3 African Americans, 2 Hispanics, and the rest are white. You'll see them do things like that. And then after the verdict comes down, you'll hear them say that, you can remain anonymous, or you can reveal your name and talk to the public if you want to, but it's up to the juror to say, okay, I'll talk to the public, and then reveal who they are, but then they can't give the names of other juror members or who was the juror that was the holdout or that type of thing. So that is common. That happens all the time. But it seems with this case, they're trying to take it a step further. So then the next section is called background. And so the charged crimes. The defendant will be tried on the charges described in a third superseding indictment, which was returned on March 12, 2020. And you guys can go back and read that if you're not familiar with it. I read all of the indictments. You just need to go back. That came out March 12th, so the video would have been around March 12th, 13th, or 14th. And you can find all of my coverage of the R. Kelly case under the playlist R. Kelly series. And so it says the indictment charges 1 count of racketeering in violation of USC 18, 1962C involving 14 racketeering acts. Count 1, 3 counts of Mann Act transportation to engage in illegal activity in violation of USC 2421A. Counts 2, 6, and 8, 3 counts of Mann Act coercion and enticement to engage in illegal activity in violation of USC 2422. Counts 3, 7, and 9, 1 count of Mann Act coercion and enticement of a minor in violation of U.S. Code 2422B. Count 4 and 1 count of Mann Act transportation of a minor in violation of USC 2423, count 5, and all of these are under the United States Code 18, and then these are the sections, like when I'm reading 2423, that's the section. The racketeering acts and substantive crimes charged in the indictment relate to 6 different victims identified in the indictment as Jane Doe number 1 through Jane Doe number 6. As charged by the grand jury for over 2 decades, the defendant was the leader of a racketeering enterprise. And then they basically just go and give the history. And like I said, if you want to know what they all said, go back and check out the video. I'm not going to read through all of this because this is a 16-page document. And then they're repeating, stuff like he made them call him daddy. They were forced to wear baggy clothes. He isolated the women. He's maintained his leadership and control of the enterprise by demanding absolute commitment from its members, not tolerating dissent, and obtaining sensitive information about members and associates of the enterprise in order to maintain control over them. And we all know that this is stuff that came out of the surviving R. Kelly docu-lies that they have created this indictment on. Then Section 2, media coverage. The government anticipates that trial in this matter is likely to attract significant media coverage given the defendant's celebrity status as a well-known singer and performer and the popularity of the docuseries Surviving R. Kelly, the first installment of which aired on the Lifetime television network in January 2019 and is currently available on Netflix, which explores allegations that the defendant engaged in abusive relationships with minor females and adult women. Indeed, the case and the defendant's other criminal cases have already garnered significant and widespread media attention. For example, upon the defendant's arrest on federal charges in July 2019, numerous print, internet, and television sources both in the New York City metropolitan area and throughout the United States, published stories. See Rick Rojos, Mayer Zaveri, and Michael Gold. U.S. prosecutors filed new charges including pornography against R. Kelly. New York Times, July 12, 2019. Blake Assop, John Anise, and Rocco Parascandola. R. Kelly arrested in Chicago on New York sex crime charges. And then they just go through a list of all these articles that have appeared in major newspapers. And then that goes on for about a page and a half. Then it goes on and says, since then, these news outlets have continued to publish articles and air media accounts In addition, numerous other celebrities have made public comments about the defendant and the charges he faces in interviews and on social media. Example, Jimmy Kimmel Live, ABC television broadcast, March 7, 2019. The Late Show with Stephen Colbert, CBS television broadcast, March 7, 2019. The Wendy Williams Show, CBS television broadcast, July 15, 2019. The Today Show, NBC televised broadcast, July 12, 2019. Saturday Night Live, NBC broadcast, March 10th. John Legend, at John Legend Twitter, January 7, 2019, 10:11 p.m. And then they have the link to what John tweeted. Then they have a tweet for Chrissy Teigen, his wife, Jada Pinkett Smith, Kerry Washington, Meek Mill, Lady Gaga, Watch What Happens with Andy Cohen, Nick Cannon, and then they provide the links to all these tweets that these people made. And then the next section is argument, and it says 1, legal standard. The Second Circuit has repeatedly upheld the use of anonymous juries where there is reason to believe that the jury needs protection, and reasonable precautions have been taken to minimize any adverse effects on the juror's opinion of the defendant. And then they go ahead and cite cases, and you guys know when they file these motions, they have to cite cases that set a precedence for what they're trying to get the judge to agree to. And so they have United States versus Kadir, United States versus Pica, United States versus Quinones, United States versus Gotti, and they love quoting Gotti, the case against John Gotti. United States versus Alessino, United States versus Wong, United States versus Tai, United States versus Amuso, and it goes on and on and on. And then it says the Second Circuit has adopted a two-step process for district courts to follow in connection with impaneling an anonymous jury that needs protection. If there is, the court should then take reasonable precautions to minimize any prejudice that might arise from the anonymous jury. See Passione 949 F2D at 1192. Importantly, the use of an anonymous jury does not infringe a defendant's constitutional rights so long as the court conducts a voir dire designed to uncover any bias as to the issues of the defendant and takes care to give the jurors a plausible and non-prejudicial reason for not disclosing their identities. Alessino 44, and they give the case number. Thus, the decision whether or not to impanel an anonymous jury is left to the district court's discretion. Then it goes on to say, courts in the circuit have considered various factors to determine whether there is a reason to believe the jury's safety and impartiality needs protection. 1, the dangerousness of the defendant. 2, whether the defendant or his associates have engaged in past attempts to interfere with the judicial process. 3, whether the defendant has access to the means to harm the jury. And 4, whether the trial is likely to attract media attention and publicity. See United States versus Wilson, and then they give a couple of more cases. And then it says, notably, all of these factors need not be present. Anonymity. I'm having a moment, y'all. Is appropriate. Letting them be anonymous is appropriate when some combination of these factors is present. United States versus Ashburn. And then it says, with respect to a defendant's past attempts to tamper with the judicial process, courts look for evidence of previous intimidation, bribing, or violence against witnesses or jurors. Noting defendants had an associate threaten a witness' life and offer $50,000 for the witness' silence. And that's from a case that they're citing. And then in the second case, Passion, they quote, noting government witness had received anonymous middle of the night phone calls advising him to, quote, remember nothing, end quote. And the defendant had threatened others with a baseball bat and pistol. Noting co-conspirator had approached grand jury witness. When a defendant is under pretrial detention, whether he has means to harm the jury often hinge on the extent of his connections outside of prison. Then from the United States versus Wilson case, they say granting a motion for an anonymous jury in part because defendant was, quote, a member of the Stapleton crew, and this organization has other members and associates who are currently and will be at large at the time of the trial, end quote. Finally, whether the trial is likely to attract social media attention may be illustrated by the nature and degree of pretrial publicity. And then on the Passion case, noting the case had already been front page news, and then the Vieira case, citing a single New York Newsday cover story. So basically what they're trying to say is that R. Kelly has all these people, that are out free, who would be willing to jeopardize their own freedom, to tamper with witnesses, tamper with juries, tamper with the case, period. That they're so in love with him, and he got all these people under so much control, even though they keep saying that the man has no money. But supposedly all these people out here, all these gremlins and ghosts are out here running the streets, who are under his magical spell, under his control, and with a smoke signal or a tap on the window at the MCC in Chicago, they would be alerted to go out and bring harm to the witnesses and alleged victims in this case. So that's basically what they're saying, that they want this anonymous jury to prevent. Okay, so make it make sense, y'all. So then it goes on to say 2 procedures adequately protect a defendant's right to an unbiased jury during the use of an anonymous jury. First, the court should, quote, conduct a voir dire designed to uncover bias of an anonymous jury. First, the court should, I just read that. First, the court should conduct a voir dire designed to uncover bias as to the issues in the case and as to defendant himself. And then they go back to the Piccioni case. It says, second, to reduce the possibility that the jury will infer that the defendant is dangerous, the court should give the jurors, quote, a plausible and non-prejudicial reason for not disclosing their identities or for taking other security measures. Piccioni, and also Luciano. In many cases, courts instruct the jury that the additional safeguards are to protect against intrusion by the media. And then it goes on to part 2, and it says there's a strong reason to believe that the jury's impartiality needs protection in this case. Applying the standards and considering the factors set forth above, the interests of justice would best be served in this case by protecting the identities of the juries. A, the charges are serious. As the government has described in detail in previous filings, the defendant is charged with serious crimes, including leading a racketeering enterprise that he created and used for decades to sexually abuse and exploit women and girls for his own gratification, including through the use of bribery, kidnapping, and forced labor. The pattern of racketeering, okay, these people say forced labor, okay. The pattern of racketeering activity charged includes the defendant's commission of 14 predicate acts against 6 different victims over 3 decades. Moreover, his status as the leader of the enterprise cannot be overstated and accentuates the already serious nature of the criminal conduct at issue. The enterprise and the defendant's status within it allowed the defendant to serially engage in criminal conduct with impunity, including against minor victims. The seriousness of the charged crimes is also reflected in the penalties the defendant faces, which include a mandatory minimum of 10 years imprisonment and up to life on counts 4 and 5, up to 20 years imprisonment on count 1, up to 20 years imprisonment on each of counts 3, 7, and 9, 10 years imprisonment on each count 2, 6, and 8. The gravity of a defendant's situation creates significant incentives to threaten jurors or otherwise seek to influence them through bribery and other means. Now, y'all already said the man ain't got no money, so what he gonna bribe the people with? I don't know. So then they cite United States versus Gotti, impaneling anonymous jury. This factor thus weighs heavily in favor of impaneling an anonymous jury in this case. And then B, the defendant has the ability to interfere with the judicial process himself or through associates. The defendant and his associates have previously attempted to obstruct justice, a factor that weighs heavily in support of it being an anonymous jury, because I ain't fighting with that word. I don't know why I can't spit it out. As set forth more fully in the government's detention memorandum dated July 12, 2019, October 2nd, 2019, and April 17, 2020. And during prior bail hearings, the defendant, together with others on behalf, has a history of obstructive conduct, including the following. And keep in mind, he has never been charged with obstruction prior to this case, so therefore there is no conviction. Therefore, there is no proof that he would actually obstruct justice, or no proof that has been submitted to support their claims. So it says, in connection with his trial in state court in 2008, the defendant persuaded multiple individuals to testify falsely before a Cook County grand jury. Indeed, the indictment the defendant faces in the Northern District of Illinois charges him with conspiring to intimidate victims and conceal evidence in an effort to obstruct law enforcement, including with respect to an investigation in the 2000s that resulted in the defendant's 2008 state court trial, charges of which he was acquitted. Specifically, the Northern District of Illinois indictment charges that in 2001, the defendant and another individual began paying an acquaintance hundreds of thousands of dollars to collect videos of, so we saw with the Lisa Van Allen mess. When the acquaintance later planned to hold a news conference to publicly announce that he had recovered the videos, the defendant and others paid him approximately $170,000 in exchange for agreeing to cancel the event. The defendant and another individual also agreed to pay two persons for their efforts to return the videos, but only after they took polygraph examinations to confirm that they had returned all copies in their possessions. Now, even if that took place, think about it. If you had these videos out there, and now considering this is a time before it became fashionable to have sex tapes released, Kim Kardashian set the standard when she became famous. I mean, let's be honest, the Kardashians aren't really famous because their father successfully, was a part of the dream team that successfully got O.J. Simpson acquitted. The Kardashians, as we know them today, became famous because of the Kim and Ray J sex tape. And so that made it popular for people to have sex tapes and they mysteriously get leaked to the public. But back when all of this was going down in 2001, 2002, it wasn't popular to have a sex tape floating around. And so I believe that they could easily argue that this wasn't about extortion or bribery or anything. It was about protecting your privacy and not wanting to be embarrassed or the people that you are partners with to be embarrassed, and that's what made it important to get these tapes back. And so then the next section says, following a civil lawsuit filed on behalf of Jane Doe number 6 against the defendant, and we all know that is Faith Rogers. A lawyer for Jane Doe number 6 received a typewritten letter in 2018 purportedly signed by the defendant. Enclosed with the letter were 2 pieces of paper that contained images and typewritten text. Among the images were photographs of Jane Doe number 6 that had been apparently cropped to not disclose certain body parts. Beneath those photographs was text including, quote, "I assure you this would not be considered a Sunday go-to meeting dress." The next 2 pictures have been cropped for the sake of not exposing her extremities to the world yet. Based on the content of the letter and photographs, it is reasonable to conclude that the letter was sent at the defendant's direction and or for his benefit, advising Jane Doe number 6 of his intent to maintain compromising photographs of her in the attempt to convince Jane Doe number 6 to abandon her lawsuit. Now, the reason this doesn't make sense is because if you believe Steve Greenberg and others who have been close to this situation, he knew all along. He knew, like when he went on tour in like 2017, 2018, that was to get his money up because he knew that the feds were investigating him. He knew about Surviving R. Kelly coming out, being in production. So why would he like be sending stuff to people, like engaging in behavior that could come back and haunt him? Like, that makes no sense. And then I think I have shown you guys this letter. It might be under one of the Faith Rogers, where I talk about the information in her case. I may show a picture of that letter. But now here we are with people, you know, on YouTube, you know, claiming that they're receiving letters from him, that they are, you know, receiving mail from him. And are these handwritings matching up? Is the signature? Because the signature on that letter that was allegedly sent to the Lydia, and I told you guys about her, I think she might be disbarred at this point, because remember, she was found guilty for trying to conceal assets against the government in a lawsuit with her aunt. But she was handling the case at that time. And I think the hand on that document is totally different from the handwriting on these other documents that folks claiming that he's sending out, you know, claiming sisters and all this other stuff. So we need a handwriting analysis done for R. Kelly to see which one of these letters he done really wrote to people. But that, you know, that whole letter I think could be easily disproved if that's not his signature on that letter. And then plus it would just really be stupid of him to have done that, knowing that you're under investigation, knowing that this docuseries is about to come out. Like, Faith Rogers suing him is nothing compared to what was going to happen in this docuseries. So why would he put precedence over, you know, trying to intimidate her based on some frivolous lawsuit where 2 jurisdictions had already said that your case is not prosecutable? So Texas said that they weren't going to prosecute him for her claims, and New York said they weren't going to prosecute him for her claims, her allegations. So why would he care about a lawsuit? Like, wouldn't he just use the fact that 2 jurisdictions have said you don't have a case? He could put that in the lawsuit and easily defend that. Why make a bad situation worse by trying to intimidate her when you got all these other people that's about to appear on this docuseries that's about to be exposed to the world, not in a courtroom, but to the world, that you need to be worried about? So to me, that just doesn't make any sense that he would have done that. So the next section says the defendant has told multiple individuals, including one as recently as 2018, that they needed to select a side, his side or other side, and implicitly threatened that selecting the other side could result in physical harm to that person or that person's family. Okay, where your proof at? Let's see what the discovery says about that, because anybody can say somebody threatened them, but if they don't like have proof that it actually happened, did it really happen? So then section C says the media coverage of this case will expose jurors to extraordinary pressure. So let me read that again. The media coverage of this case will expose jurors to extraordinary pressure. Since the defendant's arrest, the case has garnered significant attention from both national and local media sources, which can only be expected to increase during trial. As detailed above, the defendant's initial indictment and federal arrest received widespread coverage in print and internet outlets, as well as on national and local television news programs. This factor weighs heavily in support of impaneling an anonymous jury. The expected media attention may put significant pressure on jurors to reach a verdict based on considerations other than the evidence presented at trial. For example, to either avoid the notoriety associated with the defendant or to seek out fame. Notably, courts have ordered anonymous jurors in cases with substantial media coverage, even where neither the defendant nor his associates had any documented history of jury tampering. See Kader, and then it says affirming court's decision to impanel an anonymous jury where defendants were charged with violent crime and there was extensive media coverage of the case, citing United States versus Wong and United States versus Shamos. And then that says affirming decision to sequester jury in trial by judge accused of extortion on ground that trial would generate significant amounts of publicity that would interfere with the jury's ability to remain impartial. In Barnes, the Second Circuit upheld the impaneling of an anonymous jury and noted that in a case that generated as much pretrial publicity as Barnes and in which allegations of dangerous and unscrupulous conduct abounded, precaution was best taken so that fears would not become realities. The government respectfully submits that under the circumstances of this case, the factor weighs very heavily in favor of impaneling of an anonymous jury. D, the defendant is likely to be perceived as dangerous. So now they're concerned about him, I guess. So it says, based on the evidence to be presented at trial, the defendant is likely to be perceived by the jurors as capable of inflicting violence. Come on, y'all. Multiple witnesses will testify that the defendant physically and violently assaulted them when they broke one of the defendant's rules, and that they witnessed the defendant physical assault others as well for similar transgressions. In these circumstances, the fact that jurors are aware that their identities are publicly known may subtly and unconsciously impair their impartiality. So I guess when Azrael get up there and say he beat her with that size 12 Air Force One, that's going to make the jury shiver and say, oh my God, he's violent. He may beat me with a shoe. I don't know. So it goes on to say, in Thomas, the Second Circuit found that the protection of jurors is vital to the function. I'm laughing at this point, y'all. Okay. Vital to the function of the criminal justice, and further articulated the importance of using jury anonymity. Why I can't get this word out, I don't know. As a mechanism to ensure a jury's fair and impartial verdict, free from fear or intimidation. And so they note here about that case, it says the case has also garnered significant attention from various individuals on social media, including apparent fans of the defendant and his music. Some social media postings have sought to intimidate, threaten, and denigrate individuals perceived to be cooperating with the government's investigation or potential witnesses at trial. Whether or not such efforts are connected to the defendant, it is likely that similar efforts will be made to influence jurors on social media in the event that the jury is not anonymous. Now, first of all, when you own a jury, the jury instructions clearly say don't be watching no news, don't be on social media, don't be listening to the radio, don't be on YouTube. You know, they basically, in every jury instruction that I have ever heard, they tell people do not look for information about the case. Now, whether the jury is sequestered or anonymous, I think they're going to know who the defendant is, right? Once they get into trial. And so if they want to go and look up this information, they are going to look up that information. And the only way you can stop that, which I agree is about sequestering the jury, because I do believe that the jury does need to be sequestered. I do agree with that. But are you going to take the TV out the room? Are you going to bar them from having their laptops, their cell phones, any way of communicating with the outside world? That's the only way you can stop them from looking up information. But I think basically at this point, any potential juror already knows about the R. Kelly case, has already heard something about the R. Kelly case. And trust me, if you are in the Eastern District of New York and you get a questionnaire, about serving on this jury, based on those questions that I read to you guys, people will know that this is the R. Kelly case. Now, just come on now, let's be for real. So then it goes on to say, oh, and then another thing I want to point out, you guys, Sharon has done like a bunch of y'all. Sharon love to do them, Sharon Winbush, love to do the little mini videos that she be making her point quick, fast, and in a hurry. But when I log on to her page and see Sharon done posted about 5 videos, and each video about 50 seconds, I be like, okay, they done piss Sharon off and she about to go off on somebody. But after reading that notation where they were talking about social media influencing the case, Sharon made a good point in a couple of her recent videos where she says, you got these people online talking about that they're communicating with him, that he's sending them letters and whatnot. And then that's kind of like what they're talking about, saying that, oh, he's able to reach out to these people and send messages to these people, you know. So why would you be sitting on there saying, you know, before a year ago, I had never met this man, and now I done told him that we're related, and now all of a sudden he's sending me messages and he calling me and all this stuff. Like, it makes absolutely no sense. And even if he was doing this, why do you have to go to social media and broadcast it to the world that you got a phone call or you got a letter, or, you know, and then like that whole stupid thing with the message from, you know, the phone call where it was supposed to be him talking to Jocelyn on the phone. Like Sharon pointed out, like, you can't be on the phone, you locked up, and you telling somebody, oh, record this message and send this message out to all my fans and tell them, you know, those are my sisters, and, you know, don't be mean to them or whatever. Like, this man got facing life in prison. What does he care about some women he met less than a year ago and what people are saying or thinking about these women? And so go back and look at Sharon's video. She be making some really good points, and the madder they make Sharon get, the more she be coming with it and be like, wake up, people. You know, this is for the people in the back. Just think about it. If this was you, put yourself in that situation. If this was you, would you really care so much that you would need to go out and make this statement, you know, make this phone, risk being caught making a phone recording, telling somebody to record a call coming from a federal prison, and then put it on Facebook so that, or not Facebook, but put it on social media so everybody know I support these people, you know. So just when you think about it and you see how they're putting this in indictments, it just makes you think, like, who is really for him and who is really against him? And are we all being set up? You know, like, because this has been the craziest case I have ever heard of in my life. But anyway, let me get back to this. So after they talk about, you know, people on social media, you know, intimidating folks, it says, as a practical matter, we cannot expect jurors to take their chances on what might happen to them as a result of a guilty verdict. Obviously, explicit threats to jurors or the families, or even a general fear of retaliation, could well affect the jury's ability to render a fair and impartial verdict. And it goes on, then it quotes something else from the United States versus Barnes, and it says, affirming district court's use of an anonymous sequestered jury because it, quote, comported with this obligation to protect the jury, to assure its privacy, and to avoid all possible mental blocks against impartiality. Says, for all of these reasons, an anonymous and partially sequestered jury is warranted in this case. And then section 3, an anonymous jury would not prejudice the defendant. Once a district court determines that there is strong reason to believe that the jury needs protection, it may impanel an anonymous jury, provided it takes reasonable precautions to minimize any potential prejudice to the defendant. United States versus Balomo. Granting motion for anonymous jury and noting the requirements, quote, that a balance be struck between the government's interest in the judicial process and the defendant's interest in preserving and safeguarding the presumption of innocence. And then they cite a couple of cases. And then it says a defendant has two legitimate concerns that are potentially affected by a decision to impanel an anonymous jury. A, the right to make informed choices during the jury selection process, and B, the right to be tried by jurors who are not prejudiced by reason of their anonymity, being anonymous. Both of these concerns can be readily addressed. A, an anonymous jury would not burden the defendant's ability to make informed choices during jury selection. Although a defendant has the right to a meaningful voir dire or potential jurors, see Rosales Lopez versus United States, the decision is to the question to be asked in voir dire largely rests within the informed discretion of the trial judge. United States versus Silva. Absent a clear abuse of direction or discretion, trial court's ruling on questions to be asked will not be disturbed. United States versus Barnes, noting that as long as defendants' substantial rights are protected, designed to uncover bias as to issues in the case, and as the defendant himself, then reasonable limitations on the questioning should not be disturbed on appeal. The information that will be kept from the parties and counsel, if this motion is granted, namely the names, address, and places of employment of prospective jurors, is not crucial to the jury selection process. In selecting jurors, the parties will learn, among other things, the geographic area where prospective jurors reside, the general nature of their employment, their age, and the level of their formal education. Indeed, the parties have already submitted a joint proposal jury questionnaire that will ensure that the parties will learn far more about potential jurors than in the usual jury selection process that occurs in trials in this district. The names of prospective jurors, to the extent they provide information about ethnicity, are not needed for a meaningful voir dire. See Georgia versus McCullen. Rule articulated in Batson prohibiting use of peremptory challenges in racially discriminatory manner applies to defendant. I don't even understand what that means. So I guess if your name Keisha, we should surmise that you are black. And let me tell y'all a quick story about Keisha. I got a niece named Lakeisha. And she used to go to this neighborhood gas station, convenience store. And so she said every time she would go into the store, the guy would say, "Hey, Keisha," she was like, "Hey, how you doing?" So finally one day she asked him, like, "Where do I know you from? Like, how do you know my name is Keisha?" And he was like, "Oh, I call all the black girls Keisha." So maybe that's what they're talking about here. Like if you got a name like Quan or Lakeisha or Jamal, they might assume that you are African American. I don't know. So anyway, B, an instruction will diminish the risk of prejudice to the defendant. Numerous courts have recognized that where you're anonymous is necessary, the court can instruct the jury as to why you need to be anonymous and why it's appropriate in a neutral manner that minimizes any risk of prejudice to the defendant. Although the due process clause of the Fifth Amendment protects the presumption of innocence, there is no per se rule that it may not be burdened. And then they cite the cases. Then it says United States versus Scarfo. Here the burden is slight compared to the interest in safeguarding the integrity of the judicial process and can be minimized through a proper jury instruction. Most commonly, courts have explained to jurors that their privacy and their identities require protection from the media and the public. Memorandum Order, United States versus Bassiano, United States versus Amato, Summary Order in the case of Tai, Amuso, and Totino. And then it says, in some cases, the court has explained the jury's potential being anonymous by telling prospective jurors that it would allow them to feel more comfortable in giving candid answers to the personal questions asked in the voir dire. Either of those examples would provide a credible explanation to prospective jurors in this case. Indeed, the intense media scrutiny expected to surround the trial is, in fact, a basis for the instant motion. As for trial sequestration, the government proposes that jurors be told that they are being escorted in and out of the courthouse to protect their privacy and in order to ensure a timely start to each day of trial. The practice has been routinely followed in this district in recent years and should be followed here as well. And then they cite cases where they had the U.S. Marshals escorting the jury, and some of the cases, United States versus Devache, Bassiano, Stone, McGriff, Wilson, Aguilera, Nelson, Orino, Melpiso, Cotolo, and Tai. And so all those United States versus the names I just read. And then last is the conclusion. It says, for the foregoing reasons, the government respectfully requests that the veneer and petite jurors in this case be anonymous and partially sequestered. And let me look this up real quick here for you guys and for myself. Voir dire. Let's see what this. Okay, voir dire is a legal phrase for a variety of procedures connected with jury trials. It originally referred to an oath taken by jurors to tell the truth i.e. to say what is true, what is objectively accurate or subjectively honest, or both. So basically they're talking about the juror questionnaire, and they expect them to be honest and truthful about that. And they want the, jury selection to be anonymous, I guess. Now, when I'm reading this, I'm not reading that the normal jury process would not take place. And when I say normal jury process, so when you're trying to select a jury, say you have 100 people, and then you have the prosecution and you have the defense, and then each one of them have, and I said the word earlier when I was reading this document, but it's where you can strike a jury because you think that they would rule, based on their answers to the questions that are given. You believe that they will automatically be biased against the, either biased for the prosecution or biased for the defense. And they usually get like 3 or 4 strikes on each side. And so it seems to me like, the lawyers are still going to be in there. And I think sometimes the defendant is in there too when they're selecting the jury. Maybe not in this type of case, but no, they're not. Because remember, I was telling you guys about the court case. We weren't in there with the defendant. Yeah. So strike that part. I don't think R. Kelly would be in there when they're actually, trying to break down. And basically, if you have 100 jurors, say, half of them are going to be thrown out before, just based on their answers to the questionnaire. They're not even going to make it to the next phase. So then you get to the next phase and say you got 50 people left in there, and then they do another process of elimination, and then say you end up with 25 people out of that 100 people. Then those people, the defense and the prosecution gets to ask them questions, and then based on their answers, they have these 3 or 4 strikes where they can say, no, I don't want that person. Preempted, I think preemptive strike is what it's called. And so they can disqualify that person and say, no, I don't want that person. And then, so say Steve Greenberg say, well, I don't want Tracy on this trial because of, her views. And then the prosecution can come in and say, and I probably should do this vice versa. So say the prosecution comes in and says, I don't want Tracy, as a juror on this case because, her views on this topic, means that she would not be fair, to the government, and she'll rule in favor of the defendant. Then Greenberg can come back and say, well, they could either agree with it and I'm off the jury, I'm out of the jury selection process, or Greenberg could come back and argue and say, no, you're being prejudicial. She seems like she's, would be objective and fair-minded. And so, no, we want to keep her, and so then they, argue back and forth. And then I think the judge eventually, makes the decision to say whether that person can serve on the jury or they can't serve on the jury. And so that's basically how it happens. And so it doesn't appear to me that his legal team will be prevented from being a part of that process. Now, that's how I'm taking the document. I'm reading the document as it's a typical request for a anonymous juror and a jury, as well as a sequestered jury. And so, unless you guys heard something different. Now, I didn't agree with some of the statements that they made trying to support their arguments. I feel like their arguments are fairly weak, but we already know the judge has already shown that she pretty much favors the prosecution and is going to grant them whatever else it is that they want. And so if she does that, will they then appeal to the Second Circuit? And so all of these maneuvers that we're going to start seeing now most likely will delay the trial and push the trial back further. So it'll be interesting to see. And then I said this about a month ago. I'm going to say it again because it ain't happened. But we should start to see some motions filed asking to strike some of the discovery that has been presented in the case. Greenberg still claims that they haven't gotten all the discovery, but we'll have to wait and see how true that is. But we should expect to start seeing motions asking to strike information, I think strike witnesses from being on the case, and the defense presenting who their witnesses are going to be, the prosecution submitting who their witnesses is going to be. So things should start picking up, hopefully in the coming weeks. I thought it would have started picking up by now, but it hasn't. But we should start seeing more motions filed and expect to see this trial date delayed. And then the fact that the Northern District of Illinois, the judge in that case, Linebetter or whatever his name is, he did request some specific information from the Northern District of Illinois, and they basically sent him a general statement, and they didn't answer his questions because he asked for exact dates. He asked for witnesses, the victims' names, the victim names and all of that, and they did not submit that to him. And I haven't checked in the past week, but prior to that, they had to submit that information on the 22nd of June, and they submitted their response on the 18th, and I checked for about a week and a half, and the judge hadn't filed any information, and Greenberg hadn't filed any information contesting what the prosecutors in Illinois had stated. So I don't see how their case can start on October 13th when this case is supposed to be starting the end of September. And then remember, the state case is also supposed to start on September 14th. So I don't know how they call themselves going to do all three of these cases, pretty much overlapping each other. So I am predicting that all three cases are going to be pushed out further. And so hopefully the appeal for the detention will be looked into immediately, that they will agree to hear the arguments and then, take it from there. Otherwise, if they continue to hold him in this state of COVID where he can't meet with his lawyers, and they take this case to trial in September, or you can truly expect that if he is found guilty, that he would have an immediate grounds to overturn that decision. So guys, that's it for me. Let me know what you think. Are you understanding this the same way that I'm understanding it? That it's not as bad as people are thinking that it is? Or are you seeing something different? Remove the biased language that they use, the assumptions that they're using, the innuendo that they're throwing in, and just focus on wanting an anonymous jury and wanting an anonymous jury, and that meaning that the defense just won't have the names, the address, and the place of employment, and they're wanting a sequestered jury. Just looking at that, do you see this as a negative for R. Kelly, or is this just a standard practice that you have seen yourself in high-profile cases? And high-profile, not necessarily meaning celebrities, but high-profile like police shooting cases, mob cases, those type of cases that garnered a lot of media attention. The O.J. Simpson trial. Do you think that it was prejudicial to sequester the jury, or prejudicial that the defense did not have the name, address, and employment? Because according to this, they'll have enough information to surmise what the person does for a living. They just won't know what company or what industry they do it for. So I'm going to go ahead and end this. It's long enough. Let me know what you think in the comments. Rate the video, subscribe to the channel if you haven't done so already. And until the next time, I should talk to you guys later. Bye-bye.